Probate refers to the legal process for distributing the assets of a deceased person. Probate court is a special division in the court system for handling this process and other similar matters. When a person goes to the court and asks for an order to transfer a deceased person's assets, it's not called a lawsuit, it's called probate. Let's look at some examples of the use of the word probate in a sentence. First sentence: no, we cannot sell mom's house. The estate is still in probate. Second sentence: when I was going through dad's mail after he passed, I saw a bill and I called them to tell them he was no longer with us. I thought that would be enough for the credit card company, but then they asked me if we had begun probate. Third example: my grandfather left in his will that I should get money in his bank account to pay for college. But when I showed the bank teller, she refused, didn't give me the money, and said they needed the orders from probate court. So you can see, probate is necessary for certain assets left in the deceased person, also called the decedent's, name at the time of death. To determine which assets are probate assets, we start by identifying which assets are not. Probate is usually not necessary for property held as tenants by the entirety between husband and wife, property held as joint tenants with rights of survivorship, or for assets that have a named beneficiary, or assets already in a trust. Assets that transfer automatically upon death do not go through probate. But did you know that probate and wills are virtually marriage partners? If a person dies without a will, the state laws decides who gets the property of the decedent. But this does not happen automatically. When an action is filed in probate court, the assets will get distributed by court order. Having died without a will, that court order corresponds with what the state law says about how property should be divided, not what that person wanted necessarily. Contact an attorney to learn more about the order of distribution of a person's property without a will. But with a will, many people believe that if one is just created before they die, then probate or orders from the court is not necessary. This is just not true. Even with a will, probate may be necessary if assets are not transferred to heirs and beneficiaries by some other means. A will does not transfer property. An order from probate court does. A will is a writing that records what that person wants done with his or her property after she passes on. If you do not want to follow what the state law says about who is entitled to get your property, you need a will. Once your will is in probate, the court ensures that the right process is followed. Simply put, the probate process is a system for making sure that assets that don't transfer automatically go to the right individuals upon a person's death. Maybe you've heard it said, and it is true, many people want to avoid probate. Probate can be costly, and it can take some time to administer. If you're in the process of doing your estate planning, your experienced attorney will offer you alternatives that may help you to avoid probate. However, if you're a beneficiary or heir to property or an executor, you need to go to probate court, the probate administration process does not have to be dreaded and long. Probate can take weeks, months, or more than a year. The time varies. But certainly, probate can be had with minimal delay and in a cost-efficient manner. If you're looking for a caring, competent, and trusted attorney to handle your probate matter, contact us for an appointment. Go to our website, thelawadvantage.com. And if you've had experience dealing with probate court, we want to hear your comments. Comment below and click like.